The fallacy of reform. The past 2 decades of futility in the family rights movement have seen the vast majority of family rights activists crying for reform of the system. The reformers seem to think that if legislators are lobbied long enough and hard enough and by enough people, something might be done that might alleviate some of the enormous suffering that has been inflicted upon the victims of the family court racket. That is true. Something might possibly be done if enough time, effort, money, and lives are spent on that continued attempt. Unfortunately, over 20 years and counting has shown almost zero improvement. Getting legislation passed that would be meaningful is enormously difficult. Even if something was finally passed following the Great Compromise legal process, it would likely be very, very watered down. In the meantime, during this lengthy ordeal, millions more lives would continue to be destroyed. Countless FRAs, family rights activists or advocates, will continue to become penniless, become homeless, become suicide victims, or all three. That is a very long line if you would like to be in it. There are plenty of openings. Continued futility only leads to more victims. The reform approach is predicated on the false notion that this nation needs some more laws to deal with family court racket. That is an incorrect premise. There is plenty of law already on the books that should deal very effectively with the problem. There is a widespread misunderstanding of what the problem is, even among family rights activists or advocates. The vast majority think that what has happened to them is a matter of misunderstanding of their case, overreaching or unfairness by the judge. The FRAs have been led to believe by the moles, lawyers, and judges that the judges act against them in legally acceptable ways. That the judges are simply using their legitimate discretion and that they have absolute immunity. They think that repeated filing of motions and appeals will make things right for them. They entertain the notion that if they file just one more time and dot a few more I's and cross a few more T's, they will receive justice. Boy, that was me for 12 years. I kept appealing, always getting shut down. That is a very incorrect assumption, which is based upon the idea that the judges involved are good, honorable people who have a propensity to do the right thing in accordance with the law. That's a very false and costly mistake. Going along with that point of view and approach has cost the American people enormously. This is the problem. The judges involved in the family court racket are crooks. They violate the law on a regular basis. They violate the rights of American citizens. In doing so, they're committing felonies pursuant to U.S. Code Title 18, Section 242. They are not being indicted and prosecuted for their numerous crimes against the American people. The solution: the family rights activists and advocates should collectively demand that the crooked judges be indicted and prosecuted for their crimes. The American people need to demand that the law be enforced. When the crooked judges go to prison and when the crooked judges go to prison, the family court racket will come tumbling down. The myriad of abominations that are inflicted upon the victims of the family court racket stem from illicit rights violating court orders issued by the crooked judges. Those illicit orders are criminal. They are felonies. Don Rufty, North Carolina. Another inadequacy of seeking reform is that even if something is successfully tweaked somewhat with a new law, that would only help a little going forward. It would do nothing for the existing or past victims. It wouldn't bring anybody's kids back or put any crooked judges in prison, nullify their crimes, or redress any prior felonies committed. Exactly. Yeah, Don's in my cases are decades old now. You pass 50-50 legislation now, that's not going to do nothing for us or the millions of others like us whose cases are water under the bridge and ancient history.